Joe McCoy with High Tech Compliance Associates, and thank you very much for attending our webinar on releasing medical records. High Tech Compliance Associates has been in business for 13 years, and we specialize in helping offices, both big and small, achieve HIPAA compliance in a time and cost-effective manner. Today's webinar is all about releasing medical records, which we have seen major changes in the past few years, and maybe you don't know the difference between an authorization and a right of access request. So we have today our senior expert in HIPAA compliance, Michael McCoy, to present to you today, releasing medical records, the intersection between HIPAA and information blocking. Many of the documents that are used throughout this presentation are available in the handouts tab, including the whole slide deck. So if you want any of those documents easily downloadable, please check out the handouts tab. And again, thank you very much for attending this webinar. Without further ado, here is Michael McCoy with the webinar.
Thank you, Joe, and welcome everyone. So today we're going to help you understand the new requirements as to releasing medical records. With information blocking and the new access guidance, things have changed. So it should not take a federal investigation before a HIPAA-covered entity provides patients with access to their medical records. That was from the director of the Office for Civil Rights. And we want you to know they are taking seriously a patient's rights to get their medical records. So today, back in 2019, HIPAA and the OCR came out with the Right of Access Initiative. It really changed the way we release medical records. We have found that most practices are not aware of this access initiative and the rights that are afforded to patients under it, and that's what this webinar is all about today. We're also going to show how the new information blocking regulations will affect the access guidance, and again, your responsibilities to share medical records. Now, you may not have celebrated it, but the government did. Data Liberation Day. Information blocking has been with us and has been the law since April 5th of 2021, but on October 6th, the expanded definition of what you have to release under information blocking took effect. And again, the government called it Data Liberation Day and actually celebrated it. Now, the reason that you're here today is to learn so that you don't get caught up in any of these actions. And this was something that was just released by the Office for Civil Rights. They enforce HIPAA. 11 enforcement actions to uphold the patient's rights under HIPAA. That is out of 38 since the initiative began. So a total of 38 fines. And the OCR basically created the initiative to support individuals' right to timely access to their health records at a reasonable cost under the HIPAA privacy rule. Violation of these rights on these 38 fines that they've given out have averaged $54,000. So you could be a single practice physician and get a fine of up to $10,000, or I think the most we've seen is about $38,000, to a larger organization where you may get hundreds of thousands of dollars in fines. So the government is serious about this and they are enforcing it. I can tell you from our experience with our clients that there may have only been 38 fines, but there's been a lot of enforcement activity on this. Most practices get the message when they get that call or email from the OCR and get it resolved. But if you don't, there are going to be serious consequences. So today we're going to go over the 5 most common requests for medical records. 1, when the patient requests records for their own purposes, or the personal representative. And remember that a personal representative stands in the shoes of the patient. So when we're talking about minors, the patient is the minor, but the personal representative that has all of the rights is the parent or personal representative. Now, I said that, but I don't actually mean that, because there are times under state law that the patient themselves will have the right to consent, and we'll go over that. Number 2 is the patient's right to direct their medical records to a third party. This is an expanded definition under information blocking that we will review. Responding to subpoenas, something that every office gets on a regular basis. And there are two types. There are the subpoena coming from the patient's attorney and the rules we have to follow there, and the responding to subpoenas from the opposing attorney, and how that differentiates from when it's the patient's attorney. And then the last thing that is something that is going to be a big boon, I think, to most offices is under information blocking provider request for continuity of care purposes. So the first thing to understand is, what is the patient allowed to access? What records under HIPAA and information blocking does the patient have a right to get? It's probably a lot more than you think. It is called the designated record set. And OCR and the Office of the National Coordinator believe that you should already know this. This has been in place for decades, but we found that a lot of practices don't understand it. So a couple of things I want to point out on here. 2, the billing and insurance information is a part of what they're allowed access to. Number 16, health records obtained from other sources. In the past, we told patients we'll give you the records we created, but not the records that we've gotten from other providers. You'll have to go to them. No more. That is part of the designated record set. 25, claim forms. And 29, in the new expanded definition under the data liberation, imaging studies, including the images themselves, need to be made available to the patient. So the components of the designated record set are very broad. It could differ for each office, but for the most part, it's going to be any records you have on the payment or treatment of that patient. So the Office for the National Coordinator put out basically what is required under information blocking, because it does change a little bit from HIPAA and PHI, protected health information. And you can see in the bottom lower corner here that prior to October 6th, you only had to release what is called the USTDI, a limited set of data that did not include billing records. But now that Data Liberation Day is here, EHI under information blocking is basically the same as electronic protected health information. The only thing that stays outside of that and falls under HIPAA are paper records. So if you still have any old paper records, they fall under HIPAA and the right of access under HIPAA. Anything that's electronic now moves over to information blocking, since it is much more stringent than the HIPAA requirements. Now, the government has a big campaign. You've probably not seen it, but if you type in ONC or patients' health rights, you will come to an awful lot of information on the government's websites about get it, check it, and use it, encouraging patients to go to all of their providers, get access to their medical records, and use those medical records to review them and better their health. And the Office of the National Coordinator has done a lot of research and studies on this, and they have found that patients that do get involved with their medical records find errors and use the records to improve their health. So this is a bipartisan effort. You are not going to see what they call interoperability go away. This is only going to get bigger and bigger as we proceed through these rules and regulations. So now we're going to talk about the general rights under the Access Initiative. And the government says, OCR says, that you can require a written request. This is called an access request. You may or may not have an access request. Most offices that we deal with really only use an authorization form. That is the wrong document to use, and we'll go over that. But what the Access Initiative says is that a covered entity may require individuals to request access in writing, provided that the covered entity informs the individual of this requirement. So patient calls in, we have a form that for your protection, you need to come in and sign. And HIPAA says that you can do that until you find out that that creates a barrier or unreasonable delay. So you can ask for the patient to sign a form, but as soon as they say, I would have to come in there, it may be a couple of weeks before I can get to your office. That's a barrier and an unreasonable delay. We have to now verify that patient and do their request, even though they've not come in and signed our form. So verification, the privacy rule says that you can take reasonable steps to identify an individual. That means no unreasonable request. You cannot make it so difficult that the person, might not know the information to verify their identity. Like asking them, well, what was the last appointment you came in for? What was the amount of the charge that you had to pay? So we want to take only reasonable steps to verify their identity. Patients have the right under the access guidance to get their medical records in whatever form and format that they want them in. Now, you are not required to go out and purchase additional equipment. So here's one of the big questions that we'll go over when we talk about information blocking. If we do not have a patient portal, must we go out and purchase one? And the answer there is no. If a patient requests their records to be put on a CD and we do not have a CD burner, then no, we are not required to go out and purchase a CD. But if I ask for my records on a thumb drive, well, all computers pretty much have a thumb drive, so we would have to make sure that we did that. Now, thumb drives are dangerous, so we'd have to purchase them and then provide them to the patient. The biggest one here is email. And I know of a lot of practices that will not email the patient's records, and they use HIPAA as the excuse. That's actually one of the items that is in the information blocking rules and regulations, is that if you use an excuse that's not valid, you are an information blocker. So all practices are assumed to have email. You cannot get out of this requirement by saying our office doesn't use email. And it must be an encrypted account. Even though you are able, with a disclaimer, to email to the patient their records unencrypted, it's going to be in your sent folder, and it has to be encrypted at rest as well. So if you do not have an encrypted email account, get with your IT professional or call our office, get an Office 365 account, get a Google paid account, but you must be using, and every office needs to have at least one email. Now, patients must be warned. In the handouts, we have that warning that you can put on the email that this is unsecured, it could be seen by others, and the patient accepted the risk. Document that on the email. How long do you have to get a patient their medical records? Well, you have up to 30 days under HIPAA. Now, the government puts out in the access guidance that it should be as soon as possible and no more than 30 days. So could you have a complaint because you spent 20 days to get the patient record that's investigated? Absolutely. You would have to show why it took us 20 days when the standard is as soon as possible. Now, under information blocking, the standard is immediately or within a reasonable time frame. Immediately basically means if we can push it to the patient portal, it should be there when the patient goes to that portal and requests that information. If it is not in the portal or unable to be put in the portal, then that reasonable time frame takes effect. That reasonable time frame is, dependent on, what resources you have available, how many requests came in. So there's no definite time period, but I would stick within HIPAA's 30 days, where there's a proposed rule that we expect to go into effect very soon, and that's going to make it 15 days. So whether it's 30 days, whether it's 15 days, or whether it's immediately or within a reasonable time frame, we're really going to have to wait and see how the Office for Civil Rights starts enforcing this once they start enforcing information blocking. So the good news is everything I'm showing you is law, but they're not enforcing it yet, so you still have time to implement all of this in your office. Can you charge patients for medical records? Absolutely, but only under the new access guidance. Now, you could use your state fees, but only if they are lower. If your state fees are higher than these HIPAA allowable, then you must use the lower. So the OCR says if you want to just make it real easy on yourself, you can charge a flat fee up to $6.50, and you do not have to provide any patient documentation to the president, to the patient. But if you go over that $6.50, and there's lots of reasons to do that, then you have to use a worksheet. We have put together a worksheet using average cost so that you can put it together. So we can charge for the labor to put those records together. Not all of the labor, but a certain portion. The time it takes you to gather and collect is not allowable, so it's not in our time staff charges. You can charge for, if it's going to be on paper, the number of sheets of paper for the paper and the toner. And then you can also add any postage. A lot of times mailing records, you're going to spend $9 to $13 just mailing the records. You don't want to take that additional cost on, so you can charge that to the patient. Now, if the patient wants records on a CD or a thumb drive, you are not allowed to charge a per page fee for records delivered in digital format. But the way that our pricing worksheet is set up, you're not charging per record, you're charging for the time to do that. So when you're charging for between 26 and 50 pages, you're not charging a per page cost, you're charging for the time. So this worksheet will still work. Remember that this fee structure is for patients only. This does not apply to attorneys, insurance companies, or anyone else. The HIPAA rules state that only the patients get these reduced fees. Now, here's where it gets really confusing, because we have two forms. We have a patient access request. We also have an authorization form. The authorization form is what you're familiar with. The access request, believe it or not, requires a lot less information. The guidance states that it must clearly identify who is going to receive the patient information, where you're going to send that patient information, and the signature of the patient. But again, that signature may have to be done through verification, because the patient does have the right, if they're directing records to themselves or to another, to do it over the phone. But you must clearly know where the records are going to and who they're from. An access request requires by law for you to send those records. Once the patient signs an access request and says, I want my records to go, that is a legally binding requirement under the law. Believe it or not, an authorization form, it is not. An authorization form, which has a lot of different elements, things that have to be on there, such as the patient has a right to revoke. It's got a lot more protections for the patient. But an authorization form is only a form that allows you, permits you to share those records. That's why when you get a court subpoena, you get an authorization signed by the patient that permits you to, but you're under no obligation to actually complete that authorization. That's why they give you the subpoena. The subpoena is the requirement to do so. And a third form that's not actually a form is a permitted disclosure. And under HIPAA and information blocking, you should not be using any forms when it comes to the permitted disclosures that HIPAA allows, such as for continuity of care requests. We'll talk to you about when you should use a form, but for most of those requests, no form is needed, and it is actually against the law, information blocking, to request one of these forms, unless we do an exemption, and we'll go over that here. So the authorization form has these 9 required elements. And so what we've provided to you in the handouts today is the valid authorization checklist. This came directly from the OCR. And the reason I like using this checklist is if you get a court subpoena that doesn't have has an authorization, and the authorization does not list an expiration date, you are not legally allowed to send those records to that attorney, even though the patient signed it, even though there's a subpoena, even though there's an authorization, because it did not meet the legal requirements. But trying to call the attorney and telling them that you're not going to release records because they didn't follow the law is not an easy thing to do. So if you send them the valid authorization checklist and say, hey, it's got all of these, it's got 8 of them, but I'm missing this 9th, this expiration date, I can't release the records. They really can't argue with you on that. So that's kind of an easy way to do that. Remember that an authorization must also have sensitive protected health information released with a second step. So on our form, you can check yes, or the patient could write it in. But the authorization stating that it would release all the patient's records and all they do is sign at the bottom does not meet that HIPAA requirement. So we want to make sure that if the patient, say, has domestic violence information that's sensitive in nature, and even with that subpoena, I've got to have the patient sign that they can release that. So access versus authorization. Well, it really depends on who initiates the request. An access form is when the patient wants the records for themselves or when they want those records to be sent to anybody else. It could be a provider. We've seen a lot now where the attorneys try to get away from having to pay for the records with the state allowable charges that you can charge them. So they want the patient to sign a request to send to the patient. That way you can only charge either that $650 or use the worksheet. Do you need both forms? Absolutely. Because again, you want to separate a authorization. The government basically says that the authorization form is just too technical for patients to understand. So that's why they initiated the request form. We created it based off their recommendations. And again, it's in your handouts. So you should have both forms for when a patient's requesting the records and then for when it's being requested by a third party. So reminder, access rights only apply to patients, not providers. So these rights are not available to anybody but the patient. And again, a reminder that information blocking really right now only covers EHI. Most practices that we deal with, there are few, if no, paper records. So again, it's probably going to be all the records you have. So in the access rights quick guide, I kind of broke it down here, but we're going to go over real quickly the rights of the patient to get copies of their own medical records. And again, I like showing this little graphic over on the right. That's from the government's info sheet. And basically, we've got the patient saying, I'd like to get a copy of my medical records, and the medical records person saying, okay, what format do you want? And I always recommend using the portal. If you have a portal, that's the easiest and fastest way for both of you. But again, it comes down to the patient's rights. So they have a right to access that entire designated record set. You can say it's our policy for your protection to get these and use an access form. That would be the correct form here for the patient wanting a copy of their own medical records. But again, if they say that that's going to cause a burden or delay, we have to verify who they are. My recommended questions are date of birth and address of the patient. Yes, you can and probably will be fooled at some time, but as long as we document it in that telephone encounter, we're going to be safe. Form and format. So here's where information blocking is also going to kick in. If they ask for the records on a CD and we don't have a CD burner, we're going to have to fill out a content and manner exception form. We'll be going over that. And if they want it emailed, we have to give them that warning. Timeliness, again, this is going to be up to interpretation and we'll have to wait and see. But right now, under HIPAA, you have 30 days. Under information blocking, it's immediately. And in both cases, it should be as soon as possible. Fees for the copies, again, there you can charge the patient a flat fee up to $650 or use that worksheet. I do want to tell you that the Office for Civil Rights has told patients, if they don't give you a worksheet and they charged you over that $650, call us. We'll be happy to call that office and get that worksheet for you and find out why they're charging you $18.32. So we really need to make sure that that is in place and available upon request. Now, patients have a right to send their records to that third party. And again, the government puts a nice little graphic showing that the patient has that right. So here, again, it's still the entire designated record set. You can still state that it's your policy to get all of them signed. And you can also have to do your verification. So I can call you up and tell you to send my records to my brother-in-law, and I don't have to come in and sign your form. You just have to verify who I am. We always thought about HIPAA as being really a privacy protection for patient records. Now you're going to find as we go forward that HIPAA is about interoperability, sharing those records with reasonable protections, but sharing is going to be the key. Again, the form and format, if the patient wants it on paper, that's the way they get it. Now, something that I haven't mentioned yet are personal health records and APIs, or application programming interfaces. The personal health record, that is going to be, you're going to see more and more patients wanting to do this. They have the right to send it to their personal health record. They may or may not understand that that personal health record is not covered under HIPAA. So you are sending it to a facility or company that is not falling under the HIPAA protections. They will fall under FTC, but that's going to be something that we'll see more and more of in the future. I just had a couple last week where that's been requested. And typically the attorneys are setting up these personal health records so that they can, again, circumvent having to go through an authorization and a subpoena to get the medical records. When they do that, they want you to sign a form, and that form is basically a medical record certification. And if they've not used the subpoena and authorization process, I do not recommend signing with a notary these requests, because they have to have that to use in court. So I would, if they ask you to sign that, you have to send the records, but you do not have to sign that form and go through the traditional protections there to safeguard patient information. Application programming interfaces. This is going to come about in one way or the other. So the government says, hey, everybody's wearing Fitbits now, and Fitbit has an API, an application programming interface, that can interface with your EMR. And at the end of the day, the patient can press a button and send you their Fitbit results. Now, they expect your doctor to, at the end of the day, go to that patient's chart, look at their Fitbit results, call them on the phone and say, hey, great job, you got in this many steps today. That's really the way they kind of feel that this is going to work. I'll let you be the decision maker there, but it would be a information blocking violation to just reject an application programming interface that wants to connect to your EMR. That's something that you would want to call us on, or your healthcare attorney on how to handle that, but that is coming. Timeliness, again, we have to, if the patient requests it, it falls under the HIPAA 30 days or the information blocking immediately. And when they're sending records to other parties, you can still charge them the allowable fees. So I put this little graphic up because it's kind of going over everything that we just discussed. And again, this is the government's graphic. The request comes in and they get to decide how to do it. We can always push them to the portal, but we cannot require them to use the portal. The fulfillment down here at the bottom could be in person, mail, fax, email, or again through there. And again, understand that these are the patient's rights. They determine it, not you, and how your office wants to deliver the medical records. If you have the capability, you are required. Now we're going to come to the provider and continuity of care request. This is where information blocking really changes the landscape. So under HIPAA, you were permitted to share the records with another provider. You were not required to. So in this case, if I wanted to get the records and under HIPAA, the office wouldn't send them, the proper form to use is not an authorization, because that just permits them again. The proper form would be an access request, because that demands that they send the records. But the government basically says that now that if you ask for that access form, you are an information blocker, because it is now a required requirement for you to send records for continuity of care. But that doesn't mean that you're going to send all records to anybody that asks. So McCoy Family Practice calls you up and asks for a patient records, and nowhere in the patient records is that McCoy Family Practice is a part of that patient's care team. Well, now I'm in a dilemma, because information blocking says I have to share the records, but HIPAA says I also have to protect the privacy of that patient. So now I'm going to have to come and fill out an exception form. And that exception form is going to be that I do not know that this is a provider. So to protect the privacy, so it's the privacy exception, I am going to ask for an access request. Now, again, it could be an authorization form if I'm the office trying to get the records, but again, it's not as powerful as the access form. Now, the form and format, again, the office can ask for the records to be in digital format. Now, here's where it gets really confusing, and we've seen a little bit of this with our clients, and that is, can a provider charge you fees if you're requesting records from them? And the answer under the current legislation is yes. So hopefully that's not going to become common. And very soon, I do expect to see that provision being modified so that provider to provider, especially electronic copies, there can be no fees charged. Right now, if fees were to be charged, they have to fall under that access guidance request to the 650 or worksheet. Again, still rare, but we have seen it happen, and yes, they are allowed to. The attorney's request, the patient's attorney. So here again, we've got this cheat sheet for you in our handouts, but it requires a subpoena with a valid authorization. Valid just means it's got all 9 core elements. And again, that it states what sensitive protected health information can be released. The opposing attorney makes it really easy because there, the government understands that the patient is not going to be able to the office is not going to be able to get the patient to sign their request. So the government allows them to produce a notice of production. They notify the court, which notifies the patient. And therefore, without any form, just the subpoena and the notice of production, or sometimes they call it a HIPAA release, you can release those medical records. Now, information blocking. What exactly is this? I've been talking about it. And again, it went into effect on April 5th of 2021. And information blocking is, when conducted by a healthcare provider, pretty much any practice that is likely to interfere with the access, exchange, or use of electronic health information. So it is a very broad category. You don't provide access, you only have 6 exceptions that you can use not to send that information. And again, the government has a very strong belief that empowering patients to monitor their health records will help them to better manage chronic conditions, adhere to treatment plans, find and fix errors. So again, this is a bipartisan legislation. It's not going to change just because the administration changes. So these are the exceptions. They are meant to be rare, and they must be documented on a case-by-case basis. I'm going to go over them briefly here, but we do have a webinar on YouTube, our HIPAA TV, where you can get more information. But the exceptions are the 6 boxes here in gray: preventing harm, privacy, security, content and manner, health IT, and infeasibility. And they all have to meet the above standards. They have to be reasonable and necessary. They have to address a significant risk, and they have to be subject to very strict conditions. So the most commonly used will be that privacy exception. In some cases, especially if you have minors, you will have to do multiple exception forms to prevent access to the patient records. So here is one of the privacy forms that is available to you in the handouts. This is the protecting privacy. So again, I need to document that reasonable and necessary. I need to state what is the significant risk. Then I need to go through the rest of this and document in detail why I am not sharing the records or why I am not sharing all of the records. So first of all, does an exception apply? Now, let's say that, and we didn't really talk about this, but let's say that we did the exception. I don't need to do it if they're requesting psychotherapy notes. Psychotherapy notes are protected by law, not to be given to the patient, and therefore I don't need an exception form because the law doesn't allow it. But if the law allows it or requires it, that's when I have to use these exception forms. So do understand, it is the Office of the Inspector General, a very serious agency that can find you guilty of Medicare fraud if you are an information blocker, because it may cause another practice to repeat tests or exams. and you do not want to be not having the evidence to show that the reason you blocked the records was a valid and legal one that you properly documented. So the forms required, we're going to, again, this sheet over to the right is your kind of cheat sheet that goes over each of these different methods. The second page of this is the attorneys and how you have to handle those. But the forms that you have available to is the access request, again, different from an authorization form with all the 9 elements, the email warning, the pricing worksheet, our exceptions form, not listed here, but also the email disclaimer and that OCR authorization list. We also have them on share file. You can see the limit there. On the OCR authorization list is that, so you can just, it's a Word document. You can just click on that so you don't have to write it all down. It makes it real easy to go there and download any of these forms that you may want as well, or maybe you want to give access to your staff members. So that's kind of our presentation. We are the leader in HIPAA compliance. Our main focus is helping you get HIPAA compliant, information blocking compliant, and something we didn't talk about today, but also the No Surprises Act. Again, information blocking and the No Surprises Act are not being enforced right now, so we still have time to get your office in compliance and ready for these. You see the phone number there for Joe and his email address. He'll be happy to help you. So we're going to open it up to questions right now. And I'm going to go ahead and put down some of the questions I know are going to come. So first question, why are the hospitals and offices requiring our office to send a signed authorization form for continuity of care requests? Well, because they're not enforcing it yet. But soon, when they start enforcing it, no hospital or practice is going to risk a Medicare fraud charge from the Office of the Inspector General. So we will start seeing a freer and faster flow of medical records. So question number 2, when should I treat an authorization as an access request? So you may receive an authorization, but it's not really an authorization. It's really just an access request. The patient wants to get the records for themselves, or they want to send the records to another party. Again, an authorization just permits you, so it doesn't have all of the protections that an access request has. So the government says that you have to treat it as an access request, even though it came in on authorization, if the patient's requesting records for themselves or to send them somewhere else. Now, information blocking is its own regulatory beast. And what is required to show compliance with the information blocking regulations? Well, you pretty much need an information blocking regulatory binder that's going to have your compliance plan. You have to designate your compliance officer. There has to be written policies and procedures, compliance plan, staff training. All of that is required, and we have that available to our clients as well. So now, I know you do need to use the chat feature. I appreciate your time and attention today. I know I ran over just a few minutes here. And I also want to tell you for CEU credits, those will come from us through Paycom, and we will be getting with Paycom to let everybody know that we have completed this and getting your certificates out as soon as possible. So again, we thank you for attending, and please ask that any questions you have, you put in the chat bar, and we'll stay here and answer all of the questions that we receive.